This employment law video is on exit discussions. An employer or an employee, or both, may wish to discuss the employee leaving the business. There may be a falling out between the employer and the employee. The employer may, for example, want to avoid going down a capability process or a redundancy. The without prejudice rule. In order to be properly without prejudice and inadmissible in subsequent litigation, the negotiations have to be genuinely aimed at resolving an existing dispute between the parties. What amounts to an existing dispute is not always clear. The fact that an employee has raised a grievance may not always necessarily be enough. The test is whether litigation has been contemplated. One of the exceptions to the without prejudice rule, for example, is where there's been unambiguous impropriety, such as blackmail or perjury, protected conversations. Even if there's no dispute with the employee, the employer may be able to have what's called a protected conversation with the employee about the employment ending, which would be inadmissible in any subsequent unfair dismissal proceedings. However, employers do need to be careful. There are some exceptions for unfair dismissal, including where a dismissal is connected to pregnancy, where the employer does not get protection. Also, these discussions are not protected for other types of claims, such as for discrimination. There must not be any improper behaviour too. If, for instance, an employer threatened the employee that they would be immediately dismissed if they did not accept a deal, this probably would constitute improper behaviour. Good practice. Any protected conversation should be handled sensitively, particularly given that an employee may not be expecting these discussions. The meetings should take place in private and away from other staff. And although there's no legal obligation on the employer, it's good practice for an employer to allow an employee to be accompanied by a fellow colleague or trade union representative to the meeting. The employer should explain the rationale for the proposal, the financial package on offer, timings, and whether the employee will be required to sign a settlement agreement and obtain legal advice. Settlement agreements. Usually, if an exit offer is made by the employer will make it conditional upon the parties entering into a settlement agreement. In entering into the agreement, the employee waives their rights to bring certain employment claims. It's a legal requirement that the employee obtains legal advice on the terms of the agreement and the effect on the employee's inability to pursue certain employment claims. That's my video on exit discussions. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, do visit my website. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.